All right, where is it? Hold on 1 minute. Where's my?
I'm the floor monitor and I can hear you fine. Adam, can you hear me? Clerk, it's a problem with clerk. I can hear you.
Hang on 1 second, please.
We are going to hear two matters virtually today. The first one is Ledyard versus WMS Gaming. I have a little housekeeping that I need to take care of. Justice Ecker has recused himself from this matter, so we have the honor of having Judge Cradle from the Appellate Court sit on this panel. Thank you for coming in and joining us in this matter, especially so quickly, Judge Cradle. We really appreciate it.
Thank you.
Each side will have 30 minutes to argue. The appellant can reserve any portion of that time for rebuttal. If you let me know how much time you wish to reserve for rebuttal, I'd appreciate that. Justice McDonald will be our timekeeper. He will hold up, I believe it's a 2-minute warning and a 1-minute warning. Please keep track of that.
I'm sorry, Chief. Attorney Bear, can you see me or should I just interrupt?
So now I can see you. You've popped onto the screen.
Okay. Well, thanks for letting us know the problems that we may be having with the system. We're, of course, still working out bugs. I want to thank counsel for agreeing to do this matter virtually. As you know, COVID has presented some interesting problems for our entire governmental systems, especially for the court systems. And the bar has been so helpful, helping us go forward with fulfilling our constitutional duties.
I had to
want
click
thank
on
counsel. I want to thank counsel for that.
Mr. Chief Justice, I'm being informed that there may be an issue with the YouTube channel as far as the client being able to, or public being able to see the argument.
Thank you very much. Our IT people. Give me 1 second, please. Attorney Dawson just made a phone call about that particular issue. They're working on it. Do you wish to proceed, or do you wish to? What do you wish to do at this time?
Chief, this is Justice McDonald. I believe we received an email yesterday saying that the YouTube video would be slightly delayed to getting posted. I believe we got that email yesterday. If that matters.
Yes, Your Honor, we'll proceed.
Thank you. The audio version of these hearings will be on today, definitely. The YouTube, as Justice McDonald said, is going to be delayed for a little bit, but I'm not sure how long that delay will be. If those who are not speaking will mute their microphones, I would greatly appreciate it. Mr. Doss, I think I was asking you whether the parties wish to reserve any time.
Yes, Your Honor, with the court's permission, we'd like to reserve 5 minutes for a rebuttal argument, please.
Thank you very much. You have 25 minutes for your main. Whenever you're ready, counsel.
Thank you, Your Honor. May it please the court. My name is Proloy K. Doss. With me is attorney Kevin Munn. We're attorneys with the law firm of Murtha Kalina. Joining us virtually is our co-counsel, attorney Lloyd Langhammer, and we represent the plaintiff in this matter, the town of Ledyard. Your Honor, the legal question presented in this interlocutory appeal is whether the attorney's fees that can be recovered under General Statute Section 12161A are expressly limited to those that are incurred under a specific docket number. If the answer to that question is no, then the trial court must have the opportunity to make a determination of the attorney's fees that the town is entitled to recover. Now, this presents a question of statutory interpretation. And the phrase at issue here is as a result of and directly related to. In our view, that's a proximate cause standard. What the appellate court concluded is that's a standard more restricted than proximate cause. The appellate court's analysis relies exclusively on one canon of construction called the redundancy canon. It concluded that as a result of sets a proximate cause standard and therefore directly related to must be something more limited. In our view, under the plain meaning of the statute, directly related to is a proximate cause standard. And as a result of is really a causation factor. So the way we see this statute, the legislature intended for as a result of to refer to causation and directly related to refer to proximate cause. And that's consistent with the way this court has interpreted that language. On pages 15 and 16 of our brief, you will see the number of times this court has interpreted words similar to directly related to, direct cause, direct injury, direct relation. These have always connotated a proximate cause standard. So the language that's used, directly related, is similar to the language that this court has already approved on pages 15 and 16 of our brief as being a proximate cause standard. And that's consistent with what the Second Circuit has done. That's consistent with the U.S. Supreme Court has done. The confusion in the appellate court's analysis starts with the fact that in Abrams versus Young in 1997, this court referred to as a result of, in the CUPA context, to mean proximate cause. It began and ended with that. And it said, well, if that's true, then directly related to must mean something else. That was the only canon that was applied. But a more reasonable reading is this statute was adopted in 1983. And the Abrams decision didn't come out until 1997. So if you look at the plain meaning and what the legislature would have understood, it is that this phrase as a whole was the meaning proximate cause, whether you look at it as a result of is your causation, cause and fact, and directly related to is proximate cause, or you just look at the entire phrase as a whole as proximate cause. That's the most reasonable reading under the plain meaning of the statute. Because again, the appellate court didn't realize that the 1997 decision couldn't possibly have influenced the legislature back in 1983. This is also consistent with the other canons of construction, and in particular, not just the plain meaning, but the absurd results standard. And with respect to absurd results, and this case illustrates it, if we were to apply the appellate court's definition, the purpose of this provision is to ensure that the municipality is made whole, that the taxpayers of the town of Ledyard do not have to make up for the shortfall when a property owner refuses to pay their taxes. And if you adopt the appellate court's decision, then you're allowing you're putting the town in a position where they're pursuing these overdue taxes for the benefit of all the other taxpayers, and they're still operating at a loss.
Well,
and that frustrates
counsel,
government. Yes, sir.
What about your brother counsel's argument that the federal action actually started before this matter?
Yes, John. So that's not accurate. The federal action in 2006, the AC coin federal action, started before this matter.
Yes.
But what happened in 2008, and that's why we satisfied proximate cause, this collection action under 12-161A was initiated in July 2008. In response to that, in September 2008, the WMS federal action was filed. So this action, actually, the WMS federal action comes in response to and after the 12-161A action was filed.
Counsel, to that point, I'm sorry, Your Honor, Chief, I forgot to raise my hand. To that point, as I understand this record, correct me if I'm wrong, the defendant commenced the federal action and then asked that the AC coin case, which was pending before Judge Hall, would be transferred to Judge Edgington, who got this case, and combined those two cases before Judge Edgington after the fact, right?
That's correct. It was reversed a little bit. Judge Edgington had the AC coin litigation from 2006. 2008 WMS was filed before Judge Hall was to hear it, and the motion to consolidate was thereafter filed.
Okay, thank you.
Mr. Das, before I go to Justice Kahn, for your client's information, the link seems to be okay, the YouTube link, but your client needs to be on the Supreme Court YouTube channel, not the branch YouTube channel. So that may be the problem for your client.
Okay, thank you. We'll inform the client of that. I appreciate that.
Thank you very much. Justice Kahn.
As a follow-up to both the Chief and Chief Justice Robinson and Justice McDonald's question, and as I understood from the record, there was a discussion at least to try to join the initial action, the 2006. But in this case, there was an affirmative decision by the tribal nation with an understanding, it appears, in an agreement with the defendant in this case to bring an entirely separate federal action. Can you tell me, where was the impetus to join them? Was it that the town of Ledyard then moved to join, or did the tribal nation move for that joinder, or was it sua sponte by the federal court, if you know?
Yes, Your Honor. So that was all at the impetus of whether it's the tribal nation or WMS. If you look at on pages A43 to A52 of our appendix, those are the communications between WMS and the Mashantucket in terms of how they were going to bring this litigation. So the 2006 case is pending. WMS offered to join that case, and you'll see that correspondence there. They were told not to do that. They then were told, okay, we're going to bring an action on behalf of you, WMS, in federal court in response to this 2008 lawsuit. They then have WMS filing in the trial court case here the motion to stay,
Right.
which was expressly and the motion, and then in the federal court before Judge Hall, the motion, the Mashantucket tribal or WMS filed the motion to consolidate those two cases.
And was the request to consolidate it before Judge Hall or Judge Edgington? Because ultimately Judge Edgington issued the decision that was reversed.
Yeah, it was Judge. It was just from. I think it was about 3 months later before Judge Hall on the WMS federal action to consolidate with the pending AC Coin action.
And it was not your client that filed that. It was sometimes in federal court when one party files to consolidate, they go to the judge that they want to keep the case, or to move. Do you know? Was there a request that it go to Judge Edgington, or that it stay with Judge Hall, or it was unspecified?
I know that my recollection is the motion was made to Judge Edgington requesting, or Judge Hall requesting it go to Judge Edgington. And to be candid, what we didn't, the town did not object to that.
And one final question: do you think your case would be significantly weaker if instead of bringing this additional federal action, the WMS was told by the tribal nation or the plaintiffs in the federal action, hey, don't worry about it. We've got AC Coin. We'll wait until there's a decision on AC Coin, because they could have moved for a stay based on the AC Coin decision. They didn't need to bring an entirely separate federal claim. Isn't that correct?
Correct. But Justice Kahn, if I may just take a moment just to respond to that question, do I think it'll be different? Possibly, but here's another thing to keep in mind. AC Coin paid their taxes, WMS did not, and that's what triggered the 12-161A action. So if WMS had said, if they were told, you know what, let's see what happens to the AC Coin litigation on the federal issue, and they had followed the normal course and filed either a 12-111 or a 12-119 action in which they then said, okay, we're protesting these taxes, and then sought to stay in the trial court, we wouldn't be here seeking attorney's fees under 12-161A. It's because we had to file the 12-161A, and then in response to that, they filed the WMS federal action that we're here. And I saw Justice McDonald had a question, Your Honor.
I did. So, and one other procedural question. In the state court litigation, it was WMS that filed the motion to stay, right?
That's correct.
I mean, there was no obligation to stay the state court proceeding just because there was a federal court case pending, was there?
No, Your Honor. And to your point, Your Honor, the town did object to that motion to stay, and that our motion was denied. Our objection was rejected. So
WMS was trying to get the federal litigation to move first, and the state litigation would be on hold pending that. So that leads me to my second question, and it relates to the language of the statute. that we're talking about, as a result of and directly related to, it seems like everybody's talking about the docket number in this case, but the statute actually says directly related to enforcement of the lien or other collection proceedings. Did the appellate court address why this wouldn't be directly related to other collection proceedings?
No, Your Honor, it just concluded that because, and this is on page A125 of the appendix, which is this portion of their decision, they just concluded that because of the anti-redundancy provision, it had to be something more limited than proximate cause, and therefore was limited to prosecution of this particular case. And that was the conclusion.
Have you argued that directly related to, I understand your proximate cause analysis, but do you argue that this is directly related to the other collection proceedings that were in the federal court?
We argue that it's related to this collection proceeding, this 12-161A proceeding, because those attorney's fees had to be expended in order to prevail in this proceeding. But I think that that's a question for the trial court as far as, are these attorney's fees incurred in proximate cause of this proceeding?
Well, I guess my question is, given the procedural posture of this case, WMS started the federal litigation basically to create a barrier to the town to ever getting to collecting the proceedings, and the town had to overcome that federal litigation to even get to the state litigation. So is that your argument, that it was a speed bump along the way that you had to go over before you could actually collect on it, and that's why it's directly related?
Yes, Your Honor, that's correct. And Your Honor, that's consistent. We found a very similar factual scenario out of the Second Circuit, and that's on page 22 of our brief. On page 22 of our brief, you'll see the case Trustees of Eastern States, and that's precisely the logic that the Second Circuit, the district court applied, the Second Circuit affirmed, saying that if a party goes in and files a motion to stay in order to avoid litigation in one proceeding, but it's related to the proceeding, the attorney's fees that subsequently have to be expended in order to prevail, you can't avoid the plain language of the statute and the responsibility of the attorney's fees through that motion to stay. I see Justice Mullins had a question, Your Honor.
Justice Mullins.
Can I just ask you about that? And maybe it goes to your primary point that if the statute means what you says it means, all we're deciding at this point is, does it mean this docket number or not? But the amount is not really before us. What the amount of attorney's fees they'd be entitled to, that's a different question. But I'm wondering about the period from 2006 to 2008. How could that period even fit into the statute? I could see once the stay is filed and proceedings are kind of linked at that point, from then forward, there may be a question, potentially. But what about that period prior to 2008, from 06 to 2008? How is that directly related?
Your Honor, obviously that's for the trial court to make that first determination, but you're exactly correct. I think we have a hard time arguing that the fees incurred in 2006 to 2008 were caused by, or the proximate cause of a 2008 state action filing.
Justice Kahn.
And once both federal actions are joined, and I know your opponent is only focusing on the first lawsuit, not the second lawsuit, at least in their, when they refer to the federal legislation, the federal activity. In terms of attorney's fees from 2008 or from when the cases are joined, I understand your argument would be at least a portion of those fees would be to defend the second action, which relates to, in your opinion, directly to the collection of the taxes as it relates to WMS. But a portion of that those fees presumably would have been expanded even if there wasn't the second federal action, just the one against AC Coin. Are you claiming 100% of the fees from 2008 going forward, or a portion of those fees?
So, Your Honor, I think that is a decision for the trial court to make. But I will say, I think there is an argument to be made that the entire attorney's fees are recoverable. And the reason for that, I think, is this court's decision in Total Recycling. What Total Recycling said is that if the fees that are expended and necessary are interwoven or intertwined from a common nucleus, then they are recoverable. Whereas if it can be broken out, and I think that's Justice Mullen's question, if there's a way to be able to segregate, to specifically identify, then then you'd be able to break those out. And I would note, Justice Kahn, that's precisely the issue for the trial court that WMS also recognized, because you'll see in the trial court record that right after our motion for attorneys fees was filed, after the trial court's decision, WMS filed discovery. And that discovery, before it filed its appeal, was directed at that very question. The discovery questions are asking us to allocate which portions were necessary for which aspect of the litigation. So that is something that still has to be litigated before the trial court. But I think there's a strong argument under Total Recycling that they all would be interwoven.
Okay, it's going to be Justice McDonald and then Judge Cradle, but I just want to be very careful about where we are right now. I think these issues are very limited as to what the trial court may do. That may come before us in the future. So we should be very careful about how far we extend this argument. Justice McDonald?
That was basically going to be my point, that's no different than the challenge in trial court cases all the time when there's multiple counts of a complaint, but the attorney's fees are only recoverable under one count of the complaint. That's not our issue in this case. My question is that if this is let me ask it this way: directly related to, it's not a defined term, and was it ever addressed in the appellate court that it could be an ambiguous term and that the legislative purpose of the statute needed to be addressed and resolved?
It was not, Your Honor, because they didn't look at any legislative history. What the appellate court concluded is, once it concluded that as a result of his proximate cause, directly related to, it just assumed meant something more restrictive. And that's the analysis that it came up with. And they didn't acknowledge all the cases that we said on 15 through 17 of our brief, saying directly related always means proximate cause, in this court, in the Second Circuit, in the U.S. Supreme Court. But, Your Honor, if there had been an ambiguity, and we rely on the plain meaning, I think the legislative history supports our position. You know, while the legislative history is silent with respect to 12-161A, it isn't silent with respect to 12-193, which was adopted in 1975 and uses the same language. And in that case, you have testimony saying the goal was to make sure that municipalities were on the same footing as a private creditor, and the case law was that a private creditor could recover for fees that were proximately caused in a separate docket number. So we think the legislative history would cut in our favor as well. And I think, you know, that whole principle about why the municipality needs to be made whole is illustrated really by the facts of this case. I mean, we're talking about, and you see it, we put it in our brief, this is a company, a for-profit company that has property here in Connecticut, in the town of Ledyard, that generates off that private property $12.9 million a year just here in Connecticut. And they didn't pay an $18,000 tax bill that ultimately, because of each year that they refused to pay, 2006, 2007, 2008, resulted in $370,000 of taxes they deprived the town of Ledyard that the other Ledyard taxpayers had to make up. And it can't be that the town has to expend all these resources in order to chase this one taxpayer, and then the net result is to affect the other taxpayers in town from being deprived of their essential resources. And keep in mind, this town provides maintenance to the roads, it provides educational services, it provides fire and safety. All of those things help this business. It's how they get their customers there. And so as a matter of equity, it only makes sense that the town be made whole. That's consistent with the purpose of the statute, Justice McDonald. That's why we come back to looking at that legislative history and looking at beyond the plain meaning of it. If it is ambiguous, looking to the purpose of the statute, it only makes sense that this town and the taxpayers of the town of Ledyard are able to be made whole. You shouldn't be in a position where a company with these resources can try and litigate a municipality into submission, because that frustrates government administration. And as we pointed out in our brief, that frustration of government administration is an absurd result, to bring it back to the 1-2Z analysis.
Mr. Das, I believe Judge Cradle has a question, and then Justice Mullins.
Chief Justice, that responded to my question, so thank you.
Thank you very much, Judge Cradle. Justice Mullins.
I just want to see if I'm understanding your statutory argument. So the phrase "as a result of" and "directly related to" is your argument that entire phrase means proximate cause?
Yes, Your Honor. I'm going to say it two ways, if I may. Our view is "as a result of" is cause and fact, and "directly related to" is proximate cause. And that's based on the dictionary definitions that we provided, as well as the case law that summarizes the directly related is proximate cause. Another way to read it, because Abrams versus Young does say "as a result of" in 1997 meant proximate cause. Another way to read that is that proximate cause just means proximate cause. It's not that directly related to means something different. And that's the argument you'll see that this court addressed in Small versus Going Forward, footnote 4. It's cited in our reply brief, because it says you don't blindly rely on the anti-redundancy principle. And then we've also included a quote from an analysis from Justice Kavanaugh explaining why. In this case, we think it would be an absurd result and inconsistent with the plain language of the statute to simply apply that anti-redundancy principle. So, Justice Mullins, the entire phrase can mean proximate cause, or it could just say proximate cause twice, which is Justice Kavanaugh referred to, quoting Shakespeare. Sometimes the legislature just wants to be double sure. But either way, proximate cause has to be the standard, and so the appellate court erred when it gave it a more restrictive reading.
If we were to, I guess I'm wondering if there's any other scenario or maybe any analogous statute you could point to where generally when we're looking at the plain language, we do try to give effect to all the words in the statute. One of your readings would have us take this entire phrase with an "and" in it to mean one thing. Do you have any other analogous scenario where we take an entire phrase and it just means one thing, sort of where we do reject this redundancy principle?
Mr. Chief Justice, I see my time has expired. May I answer the question? Thank you.
You may answer, counsel.
Justice Mullins, I think the closest I'd refer the court to is on page 4 of our reply brief, the Small versus Going Forward principle, which is that you don't always apply an anti-redundancy principle if it doesn't square with the other rules of construction. And that's what we have here. So this court has acknowledged specifically with this particular canon that it shouldn't be dispositive. And that's the only canon that the appellate court was able to rely on to reach its conclusion.
Well, just one more question, Chief, just to follow up to that. Which other canon is this inconsistent with?
Yeah, so the answer is 1-2Z, and particularly the plain meaning rule, where you look to the dictionary definitions, the absurd results rule, which is also the second part of 1-2Z, because it creates an absurd result to be able to put the town in a position where they are at a net loss and a significant net loss, doing their actual governmental duty in pursuing a taxpayer. And then I think the legislative history, finally, to the extent there's an ambiguity, we do look at that, and the interpretation of the appellate court would undercut both the purpose of the statute that was and why it was enacted, as well as the public policy reasons that we have a statute making sure the municipality is made whole if, for the public good, it's pursuing a delinquent taxpayer.
Okay, thank you.
Thank you, Your Honor. I see my time
had a question.
Thank you, Chief. I don't want to take up much time. It's a very quick question. Do you agree with the appellate court's decision that this presents entirely a question of law for which our review is plenary? Or do you think it's a mixed question of law or fact?
I think the first question about whether or not approximate cause standard applies and whether or not there's a basically a source of right for attorney's fees is a question of law. Ultimately, the extent of that and any application of that is a question of fact.
Thank you. Thank you, Chief.
Thank you. With that, I'll reserve the rest of my time for rebuttal, Your Honor.
Thank you, counsel. You have all your remaining time.
Thank you, Your Honor.
Thank you. Are you ready to proceed, counsel?
Yes, thank you very much, Your Honors. Aaron Baer from Wigan and Dana on behalf of WMS Gaming, the appellee. Your Honors, what the town is asking you to do here is really something quite extraordinary. It's asking that a property owner be required to pay fees the town incurred in defending a separate action that was brought in federal court 2 years before the collection action was filed, not by the taxpayer, not by the property owner, but by a third party, a federally recognized tribe.
Attorney Baer, I believe when Mr. Das was speaking, he covered that issue, that the trial court hasn't decided yet exactly what attorney fees are to be paid, but just a threshold of attorney's fees.
So, yes, Your Honor, let me address that. I guess what I want to try to bring across here is that the town has not cited you to any case, not only under 12-161A, not under 12-193, the statute this was patterned after, or under any fee shifting statute at all, where a non-party to a lawsuit has been required to pay the attorney's fees of the prevailing party in that suit. So they're asking you to do something unprecedented.
Counsel, let me ask you, just walk me through the contractual arrangement between your client and the MPTN. There was a lease that had an indemnification agreement related to taxes. Is that right?
So there are business relationships between the tribe and the vendor. There are a number of vendors that leased equipment for the gaming operations. This was one of those vendors, and they do have an indemnification agreement related to taxes and litigation costs.
Go ahead.
If I might explain why I don't think that's relevant. It really requires me to take a step back, Your Honor, which is where I was going to go anyway. So with Your Honor's indulgence, if I might.
I have a follow-up. Let me ask my follow-up question first, okay, and then you can probably wrap it all into one. The MPTN was essentially the real party in interest because of that indemnification provision. Was there anything that would have prevented MPTN from intervening in this state court litigation and arguing all of its preemption arguments as the real party in interest in state court? Was there any procedural impediment to that?
So I don't know the answer to that, Your Honor, but I don't think it would make a difference under the case law and under this statute. And I think I need to explain why. Because the issue here is whether there is a close enough connection between the issues being litigated in federal court and the issues being litigated in the collection action to allow the taxpayer to be required to pay the fees to defend against those issues. Now, the reason it's important is if the issues are fundamentally different and could be litigated at any time, whether or not a collection action had been brought, and that is the case here, then they are not as a result of and directly related to the collection action. This is not a statute that says, as the town suggests, that anything necessary for the town to succeed in a collection action is recoverable. That's not what the statute says. This is a statute that requires a close proximate connection. If I can... Well,
my problem is that this entire morass was engineered by the tribe in conjunction with discussions with your client. There was nothing that would have prevented the Superior Court from adjudicating a preemption argument. And I mean, you'll agree, state court judges are qualified to adjudicate those types of claims, right?
Yes.
So this entire this entire issue could have been joined in the state court, but because of the decision made by the tribe and your client to first litigate it in federal court, why is that the plaintiff's problem because of your client's decisions?
So I think it wouldn't have made a difference whether it was litigated in the collection action or outside the collection action, because they're fundamentally different issues that could have been litigated at any time. If there had been no collection action, I want to be really clear about this.
Well, wait a minute, they're not separate. They're inextricably intertwined.
No.
Whether they can be, okay, tell me why.
Your Honor, I respectfully disagree, because let's look, supposing WMS had paid its taxes and there was no collection action. Would the federal action have continued, and would the town have continued to defend against it? Yes. That federal action has nothing to do with this specific collection action. This dispute, Your Honor, actually begins in 2001 when the tribe sues the town for trying to tax leased motor vehicles that were used on the reservation. This is a tribal sovereignty issue that was being litigated by the tribe. It was litigated before and during this collection action, and not because of the collection action, not as a result of the collection action. Let me just take a step back. The tribe's position is, and was in that litigation, that certainly property owned by the tribe and used on its reservation is not taxable. Under federal law, the tribe is a sovereign nation and is not subject to the taxing authority of the town or the regulatory authority of the town, particularly as to property used in casino gaming, which is authorized and regulated under federal law. The town took the position that it could exercise its authority if it leased, the tribe leased the property, leased slot machines, but didn't own them. And the tribe's view was that makes no difference at all. This is property on our reservation, on our territory. It is our sovereign right to decide how we acquire slot machines for use in our federally regulated activities as a sovereign nation. That dispute starts in 2001. It goes again in 2006 and again in 2008. That is a dispute that had to be resolved, and it didn't have to be resolved because there was this collection action for $18,000. It had to be resolved because it was a fundamental dispute between the town and the tribe over sovereign authority. That's why it's not connected to the collection action. If I may say one more sentence, Mr. Chief Justice, before I take the next question. We know that it doesn't matter whether the town settled the collection action against WMS. We know it doesn't matter whether they never filed the collection action against WMS, because that's exactly how this litigation in federal court starts. There was no collection action against AC Coin. The tribe files that suit because the town takes the position that it could tax property used on the reservation and that didn't violate the tribe's sovereign rights. And the tribe takes the position that it did violate its sovereign rights. And if you look at the two complaints, the federal court complaints, it's not about the collection actions. If you look at the relief they seek, it's sweeping relief, saying the town cannot assess, it cannot put property on the taxable property list, it can assess, impose, collect. It can't in any way exert its authority over this category of property, leased property used in gaming operations on the tribe's reservation.
Justice Kahn and then Judge Cradle.
So, counsel, if it had nothing to do with the collection action and you rely on the 2006 action, then why file it at all? Why not just wait until AC Coin is decided, and then the tribal nation would have its resolution that would be applicable. It's the same defendant. It's the town of Ledyard. So that's, I think, where you start your brief. You mention only the 2006 case when you set out the issue at page 4 or at the beginning of your brief. And it's not until deep into your fact on page 3, Roman numeral 3, you mention the 2006 litigation. But that's not the issue here. The issue is, why even bring the 2008? If you're correct, there's no need for the 2008.
So, Your Honor, the answer is I don't know why they filed a second lawsuit, but you're absolutely right. They did not need to. Those issues were the same, and they were going to be litigated through to conclusion no matter what. My position is there is one federal lawsuit, all the same issues. I would urge you to look at the two complaints. They are virtually identical. My position is, Your Honor, that this is one piece of litigation involving fundamental issues of federal law and tribal sovereignty that were going to be litigated from beginning to conclusion. And the fact that the town in the middle of that lawsuit filed a 3-sentence collection action seeking $18,000 in property taxes from one of the vendors doesn't magically under 12-161 mean that litigating those federal issues suddenly now is they can do for free because they have an indemnitor. This one taxpayer now is responsible for financing the defense of the tribe's lawsuit to vindicate its federal rights. It's one piece of litigation. The fact that they filed a second complaint identical to the first one essentially, and then promptly consolidated them and continued to litigate the same issues, and the town continued to defend against the same issues, does not entitle the town to recover from this taxpayer the costs of defending that litigation. It preceded and then continued, but it is the same lawsuit with distinct federal issues.
Hang on, Justice Mullins. Judge Cradle has a question first, and then Justice Mullins.
I think that the trouble I'm having is exactly what Justice Kahn articulated. Is in your brief when you make reference to the federal lawsuit. In my read of it, you refer to it as just one lawsuit, and clearly that's not what it was. And the hump that I'm trying to overcome is exactly why then that 2008 federal lawsuit was filed. In addition to that, you also have your client, okay? They used the same attorney. There was some reference that the state lawsuit was referenced in the federal lawsuit, and then your client, in addition to that, goes and seeks a stay in the state court. How is that not directly related?
So, Your Honor, we refer to the lawsuit as a single lawsuit because what the 12-161A is focused on is whether the fees the town incurred in that suit are as a result of and directly related to the town's collection action. And our position is, Your Honor, it doesn't matter that a second lawsuit was filed. The fees the town incurred, it would have incurred whether or not a second lawsuit was filed. They're identical lawsuits, and those fundamental issues of tribal sovereignty were going to be litigated through to conclusion either way. So I don't think it matters that a second suit was filed. I don't know why they did it. And as far as a stay goes, the stay is simply sought because the federal litigation could have disposed of the suit. But that happens all the time, Your Honor. I mean, the fact that one suit might dispose of a second suit doesn't mean that the second suit was brought as a result of the first suit or that it's directly related to it. I'll give you an example. Assume that there is a suit challenging an agency's regulations as not lawfully promulgated under the Administrative Procedure Act. In the middle of that, the agency files an enforcement action against a particular regulated entity under those regulations. Now, it is true that the first lawsuit could be dispositive of the second suit because if the regulations were never lawfully promulgated, then they can't be enforced. But it doesn't mean the first lawsuit or any lawsuit relating to the regulatory authority is as a result of and directly related to that particular enforcement action.
Let me ask you this. Do you think your argument would be stronger had they not filed the 2008 lawsuit?
It might be cleaner but not stronger, Your Honor. It might be simpler but not stronger. I think the fees the town incurred in federal court defending against the tribe's sovereignty issues and federal issues were going to be incurred no matter what because they're the same lawsuit. I strongly urge you to look at the language of the two complaints. Unfortunately, the second one is in our appendix. The first one is in the town's appendix. But you should look at them and compare them because they are substantively identical. And it really doesn't alter the nature of what issues were being litigated there and the town's need to defend against those issues. Your Honors, if you conclude, I want to just go back to the issue of statutory construction here because I do find it hard to believe that what the legislature had in mind when it passed this statute is that a town could essentially be rewarded by getting a taxpayer to pay all of the costs involved in this separate federal lawsuit that went on for 7 years and was litigated between the tribe and the town and not with the taxpayer. But if you conclude that it's not plain and unambiguous from the words of the statute, we obviously think it is. But if you conclude that this is a close case, then a fundamental principle of statutory construction requires you to read the statute strictly and narrowly and apply it only to matters that are clearly within its scope. Because this is a statute in derogation of common law principles, a very fundamental common law principle, the American rule that parties bear their own costs in litigation. And because it's a statute in derogation of common law, this court's precedents require it to construe that statute strictly. So you would have to conclude not that it's a close question, but that it was clearly within the intent of the legislature to bring the fees incurred in this second lawsuit within 12-161A. If not, then the argument, if the argument is it really is that broad or should be construed that broadly, that's an argument that should go to the legislature. If the town wants to read this statute as saying any litigation that has to do with our authority to tax, that's covered, or what it proposes in its opening brief, any proceeding in which that we must prevail in order to be successful in any collection action, we can recover those fees. That's an argument that goes to the legislature and not to this court under the principle of narrowly and strictly construing a statute in derogation of common law.
Attorney Baer, Justice Kahn has a question, then Justice Mullins.
Counsel, my question related to something you said about 2 minutes ago, but because you kept speaking, I'm now going to have to try to formulate it in my mind. You asked us to take a look at the complaints in the federal actions, but the trial court also took a look at the complaints in the federal action and the state action and says this is so because even a cursory examination of the complaint filed in federal court demonstrates it was an action to prevent the town from taxing the same WMS gaming machines that were the subject of the instant case. And that's at page A79. So should we also look at the federal complaint and the state complaint? And it brings me back to if the federal complaints were so similar, why bring the second one?
So to answer your first question first, Justice Kahn, the trial court is simply wrong. The issues in the collection action are were the taxes properly assessed? How much did they owe? Did they pay the taxes? The issue in the federal lawsuit are issues of tribal sovereignty and federal law. Whether this is an issue almost of territorial sovereignty, whether a town has the right to tax property that's used by the tribe in its gaming operations under federal law. That suit could have been brought any time, whether or not there was a collection action. So it's not a result of the collection action. It's not directly related to that action. It's a dispute. It's a sovereignty dispute between the town and the tribe that was being litigated and was going to be litigated. To give you an example, there's no case law. There's no cases under 12-161A, but the legislature adopted the identical language that was used in 12-193. But there is no case under 12-193 where a taxpayer is made to pay the attorney's fees of a municipality in a separate lawsuit to which it was not a party and which it did not control. But there is a case, the White Sands Beach case that we refer to in our brief, Your Honor, where it's very similar. In that case, there was a taxing authority within the town, and the taxpayer says, you have no authority to tax my property. The issue in that case happened to be whether the town had properly annexed that property into the taxing association. But it says, the taxpayer brings a counterclaim that you can't foreclose on my property because you have no authority to tax it. It would violate CUTPA if you taxed it. It would be illegal if you taxed it. And that counterclaim is litigated and defeated. And at the end of the day, the court says, Under 12-193, using the exact same language, you get your fees for litigating the case, but not for litigating the counterclaim, because that was a separate and distinct issue. It wasn't as a result of and directly related to the foreclosure action. It's a broader issue about the authority to tax that property, and that could have been brought at any time, and it is not recovered. So the fees for defending against the counterclaim are not recoverable. Similarly here, except in that case, at least, it was a counterclaim brought by the taxpayer, by the property owner, in the same action. Here we're talking about a lawsuit that was not brought by WMS Gaming. It was not in the same lawsuit. It was brought by the tribe in federal court. It preceded and then continued in federal court, litigating those separate issues about the town's taxing authority, and beyond the town's taxing authority, whether it interfered with the tribe's rights under federal law. For those reasons, they're separate and distinct, and they're not recoverable in the collection action because they're not as a result of and directly related to the collection action. 12-191.3 is the closest analog we have.
Justice McDonald.
Counsel, the plaintiff represents in its brief that the same attorney that represented the tribe in the consolidated federal action also represented the defendant in this proceeding. Is that correct?
So they did have the same attorney for part of the time. I would point out that when WMS Gaming decided not to pay the $18,000 in taxes based on the pending litigation in federal court and the tribe's assertion that it violated its sovereignty, the WMS Gaming went out and got a separate attorney's view to advise it on whether the tribe was right and whether it would prevail in the federal litigation. It doesn't matter, though, whether they had the same attorney. All of these facts that the trial court relied on are they're undisputed, but they're not material facts. They're not dispositive facts.
Well, but it goes to the question that I addressed earlier with you. You're arguing that these are completely separate proceedings, that they're not interconnected, and yet they were being orchestrated between your client and the tribe, and this procedural dance was highly choreographed, and in fact, the federal action was so important to this action. Your client said that this case had to be stayed because it was going to be determined by the federal action. I mean, that it couldn't be much more plain than that they were absolutely interconnected, and that for the plaintiff to vindicate its rights, it had to go through that federal litigation before it could lift the stay in the state court litigation, because you said it was determinative. How do you get away from that now?
Because I think the fact that you seek a stay because it might be determinative doesn't connect them in the way the 12-161A requires. These were not the same issues that were being litigated, Justice McDonald, and they were going to be litigated whether or not there was a collection action pending against WMS Gaming. That's how the federal suit started in the first place. It didn't start based on a collection action. It started based on the tribe's assertion that any effort to assert the town's authority and taxing authority over any property used on the tribe's reservation and its gaming operations is unlawful. That would happen whether or not the town filed a 3-sentence complaint seeking collections from this particular taxpayer.
That goes back to, I don't know if it was Justice Kahn or Judge Cradle, that goes back to the prior question. There was no need to file the second federal action at all. If you're correct, then the what is it, AC coin would have been determinative of this case anyway. So, what was the need for that second federal action?
I don't think there was a need for the second federal action. I don't think filing a virtually identical complaint and consolidating and continuing to litigate those distinct issues of federal law converts the federal action into something that is as a result of and directly related to this particular collection action. It was not. And I think the filing of that second complaint doesn't do it. I mean, and by the way, just so we're clear on what happened at the trial court level, Your Honor, the town's argument now that, well, maybe there were some fees that were solely related to this second action, I think that they'd be hard pressed, other than perhaps filing the identical answer they filed in response to the first federal action. But even so, Your Honor, what happened in the trial court was WMS Gaming filed a summary judgment motion saying this statute does not reach the defense costs for that federal action. And the town said it does. That's what was litigated. The town at no point during that summary judgment dispute said, well, there might be some small snippet of fees that were results that were directed solely to the short period of time where there was a federal second suit filed before it was consolidated and the identical issues continued to be litigated. So what the trial court ruled as a matter of law was this statute was broad enough to reach the defense of those federal issues in federal court, and we said it was not, and the trial court erred in finding otherwise.
Justice Kahn.
Thank you, Chief. And out of respect for you and my more senior colleague, Justice Mullins, I know he had a question. With your permission, Chief, if he wants to go first, I don't want to overstep on him.
It's fine. Whichever justice agrees to speak first.
Thank
Go
you,
ahead,
Chief.
Justice Scott.
Thank you. My question related to something you just said. You said there was no need for the federal action. It just happened. But I thought the record, there were discussions not only of indemnification, not only discussions of seeking a stay, but there was a request to just add this particular gaming, your client, to the existing litigation. And it was the tribal nation that said, no, don't do that. We'll file a separate lawsuit. So, you know, I get the, hey, you know, it just happened, we filed a new case, but here there was an affirmative discussion whether to just add to the existing case or bring a new case. So that argument seems to fall when you look at the communications between your client and the plaintiff in the federal action in 2008.
So there was no possibility of joining WMS Gaming to the federal action. Whether there was a second suit or the first suit, that the taxpayers could not have been joined. And this goes to the point that the town's fundamental position here that these two actions were not only inextricably linked, but that the federal action, the tribe's federal sovereignty action, was really all about the collection action, that's why they can recover their fees. Well, that issue was actually litigated in federal court, and the town lost twice, in the district court and the Second Circuit. It moved to dismiss the federal action on two grounds. One, that the tribe didn't have standing because the real party in interest was the taxpayer. The court rejected that, saying, no, it's the tribe that's the real party in interest because it's litigating its own federal sovereignty and federal law rights. It tried to dismiss the action under the Federal Tax Injunction Act because on the argument that the tribe's federal suit was really about the collection action in an effort to prevent the town from collecting taxes from WMS Gaming. That, and your Justice McDonald, that goes to your point. If the federal action by the tribe had been about the collection action, had been about stopping the town from exercising its authority and collecting taxes from WMS Gaming, in fact, it would have been barred under the Tax Injunction Act. But it was not, because what both federal courts had held was it was not about the collection action. It was not about stopping the collection action. It was about the tribe's federal rights, whether the town's sovereignty invaded the tribe's sovereignty, whether asserting a right to tax property used in its gaming operations on its reservation violated its rights under federal law. That was the tribe's interest, and those are the tribe's federal issues that are being litigated in federal court. So the disconnect between the collection action and the tribe's federal lawsuit was an issue that was already litigated and lost by the town in both federal courts. It shouldn't be relitigated here, but it certainly we shouldn't recharacterize what the federal lawsuit was about in a way that's 180 degrees contrary to what the federal courts thought the lawsuit was about. Thank you, Your Honor. As I said before, and I'm going to close with this, I don't think it's a close question whether simply by filing a 3-sentence complaint that the town was able somehow to convert the federal action into a lawsuit that was all about the collection action. It was not. The federal courts didn't view it that way. The tribe didn't view it that way. And it wasn't about that. And those fees should not be recoverable. But if that's a close question in your minds, if you think it's possible that the words of the narrowly written words of the collection statute, 12-161A, are broad enough to cover this, and you're not certain, the rules of statutory construction require you to rule the other way, to construe that statute narrowly and strictly, and only apply to those things that clearly fall within its ambit that the legislature clearly intended to cover. There's no evidence that the legislature intended that. It's patterned after a statute that had never been applied in that way. And there is no suit that I'm aware of and no case I'm aware of where a non-party has ever been required to pay the fees of a winning party in a separate lawsuit.
Attorney Bear, I do have a final question. I'm trying to imagine if there's any factual scenario under the same kind of litigation posture where your legal theory would fail. In other words, somebody brings an action, sort of what Justice McDonald was talking about, as a tactic, and the town would have to defend that, and then they could get fees. Or do you believe that there is no factual scenario because of the nature of the federal suit that they would be able to recover fees?
So, Your Honor, I don't know the answer to that question. It is a very narrowly written statute. I've tried to think about this. Are there other proceedings in which a town might recover their costs because it's so directly related to the collection action? And the things that came to mind are things like some sort of proceeding in furtherance of the collection action. For example, if a taxpayer was about to dispose of all of its assets, and the town wanted to assert its authority to prevent those assets from being dissipated before the collection action was finished. That might be directly related to the collection action. Maybe a bill of discovery to determine whether it has a collection action it's about to file but doesn't know if there are any assets there. It might be seeking, but those are all directly related to and as a result of the collection action. They're not separate federal sovereignty issues that could have been brought at any time and were in fact brought when there was no collection action. Okay,
the bill of discovery was actually what I was thinking about. So I appreciate your answer. Justice Khan, did you have a final question?
No, thank you, Chief. I'm all set. Thank you.
Thank you, Attorney Bear. Appreciate it. Justice Mullins, Justice McDonald, could you remind me of the remaining time for Attorney Doss?
It's 5 minutes.
Thank you very much. Sorry about that. With a smaller footprint of not being on the bench, I've lost my notes on your remaining time. I'm sorry, Mr. Doss. Whenever you're ready, sir. Your microphone's muted, sir.
Apologies again, my Justice Sotomayor moments. I keep doing that. We're criticizing our brief for referring to the WMS federal action as WMS federal action. I want to note that the nomenclature for that came from the motion to stay that was filed in the straight court litigation. That was described by WMS as the WMS federal action.
Justice Mullins?
Attorney Doss, can I just ask you to respond to if we take a look at the statute and were to conclude that the phrase is ambiguous, how would you prevent, would we not then construe this narrowly against your client, or do you have another way for us to look at it if you assume we conclude it's ambiguous?
Yeah, Your Honor, I think the answer is no. You would, if you, first of all, we think the plain meaning is its approximate cause standard, no question. Right. And the reality is that's not how strict construction works. It simply means, is there a basis for recovery, not the scope of recovery when you're talking about attorney's fees. That's not what strict construction means. And we know that because whenever we talk about an attorney's fees award, we're still deferring to the abuse of discretion standard with the trial court. We apply the Johnson versus Georgia highway standards from the Fifth Circuit, and we give the trial court a lot of flexibility of determining which attorney's fees to award. We don't apply a strict construction of that. We entrust the trial court to determine what's the hourly rate, not we only give them the lowest hourly rate. What's the reasonable amount of time? So there's a lot of discretion in there. The question is whether attorney's fees can be recovered. That's the strict construction question. Once the answer to that question is yes, attorneys Attorney Baer conceded that outside of this docket number, you would be able to. The rest of the question is proximate cause. And that's a factual question for the trial judge to make a determination on.
I mean, on the just reading the statute to come up with what it means if you're even entitled to these fees. If we read the statute and that's ambiguous, what's our next step if this is in derogation of the common law? Do we say it's on that reading it's ambiguous, so we construe it against you, or do we go to the next steps to try to figure out what it means?
You go to the next steps, and your honors have. I mean, you still go through all the number one, it's under our 1-2Z, the plain meaning, absurd results, and legislative history. I mean, the court has always done that with determining the meaning of a statute. That doesn't mean you can't strictly construe it. It is strictly construed. It means that you are allowed to recover attorney's fees. If it didn't say anything about attorney's fees, an example really there is recover costs, and the meaning of costs to include attorney's fees. Well, that would be importing new language into the statute. You couldn't, because of the American rule, pigeonhole attorney's fees into a different term. But the question of causation for that is not something that would restrict the trial court from being able to act.
Justice Kahn.
Thank you, Chief. Attorney Doss, is your argument really more focused on what the appellate court's decision, for example, at page A125, where the court says, given its restrictive language, only litigation fees incurred in the prosecution of the collection action itself would qualify as attorney's fees directly related to the collection proceeding as contemplated by 12161A. Is your argument that in that, doing that, relating it only to the collection, this collection proceeding itself is too restrictive, and that it would lead to an absurd result because there may be ancillary proceedings that go towards collection? Whether this particular federal action is one of those, your opponent says it's not. But is your argument that it is so restrictive that it's saying only related to this action itself would be collected, and that would lead to an absurd result, that there would be other types of ancillary proceedings that would not be covered when you look at the way the statute is written, when it says any proceeding?
Yes, Your Honor, and the question then is, if it's approximate cause, that's a question of fact for the trial court. And I want to note, Your Honor, again, there was a procedure available for WMS. They chose this route. AC Coin paid. The other vendors paid. So under 12161A, WMS is the only one who just ignored their taxpayer obligations, and that's why we were forced to bring this action. They then brought a lawsuit trying to enjoin payment. They weren't waiting for the legal issue to be resolved. And I know that the representation is that there were different issues. If you look at the reply to our objection to the motion to stay, this is a header from it. Quote, may I take a moment to conclude, Your Honor, or answer? Quote, a stay is appropriate because the legal issues in the suits are identical. They absolutely conceded that these are the same issues. And finally, Your Honor, I just want to take just a brief moment to conclude to talk about what's at stake here for the town of Ledyard. And that is that they had to pursue this. They had to pursue on behalf of the other taxpayers. And now they're put in a position where they had a well-funded non-taxpayer being able to litigate them into submission. They had to respond to it. They didn't blink. David beat Goliath, and the statute says they're supposed to be made whole. We just want the opportunity to be made whole. And with that, we ask that the appellate court decision be reversed. Thank you, Your Honor.
Thank you, Attorney Doss. I want to thank both counsel and the parties for allowing us to go forward on this virtual platform. As I stated earlier, COVID has really changed the face of how the judicial branch can do things. We are moving forward, and with the help of people like counsel and the parties actually going along with us to do things in a way that we've never done them before. I apologize for the technical difficulties. I also want to thank Judge Cradle for coming up to the AC to do this matter. We are in recess until the next case. Thank